Well, they probably just like.
See some adult supervision. Oh, I've got a phone.
I didn't bring them.
Hope we do not get book. I forgot my iPad, so together we'll be able to.
R is not, or the R is as well.
Exactly why. Where to teach. That's how it's all like. They'll be a little bit right there in front of the teacher with their hands.
You be good.
Timmy, we don't get.
I'll go grab a tissue.
Actually, I never did really pull girls' hair.
I won't swear.
Much.
If I thought of it, I would have. But
All right.
this meeting is going to take hours.
Right.
I
I know. Well, the food and drink are not here. I think we have everybody.
Set a real record. First thing.
Oh, there's Rachel.
First motion is to get Starbucks.
All right, we're going to get started here, folks, in just a second.
A new constitutional limit on meetings.
All right, we all here? We missing anybody?
Sabrina.
And bear with me, I'm going to be taping. No,
Sure.
Sabrina is on her honeymoon,
Oh, right.
so we will catch her when she
Congratulations.
comes back next time. She'll be back next week.
So we're still into 2014 board packets, right? I mean, yes.
Correct.
That's correct.
Because I know it's 2014 in June.
All right.
It's gonna be a long night.
Right, exactly.
Whenever you're ready, boss.
That's a good.
Okay. All right. Welcome, everybody. Good evening. The Resident Association Annual Board Meeting will now come to order. I see a quorum is present. The first order of business is the election of officers. Candidates for the offices of President, Vice President, Secretary, and Treasurer will be nominated from the floor with one board member making the initial nomination and a different board member seconding the nomination. If no second is made, the nomination fails. Nominations may only be made by members of the board. Only one office will be considered at a time. Once all nominations have been made and seconded, the nomination process for that office will be closed. Each candidate for the office under consideration will then be afforded an opportunity to make a brief statement as to why he or she is qualified and interested in serving in that position. Once all candidates have concluded their statements, General Counsel will distribute blank secret ballots for you, the Board of Directors, to use in casting your vote for the specific office under consideration. Secret ballot voting is authorized for use in the election of board officers under Section 55-510.1.b of the Virginia Property Owners Association Act. Resident Association uses secret ballots in the election of officers, even if only one candidate has been nominated, to afford each board member the opportunity to cast his or her ballot anonymously, without concern of repercussion of not voting in the same manner as his or her peers. When ballots for an office have been completed, they will be collected by the General Counsel. General Counsel and the Assistant Secretary will leave the room and tabulate the results. For a candidate to be elected to the office, he or she must receive a majority of the votes cast by the Board of Directors. Once tabulated, General Counsel and the Assistant Secretary will come back into the room. General Counsel will announce the winner, and the next office will be considered. Please note that General Counsel will provide no information as to the number of votes received by an individual candidate. The process will repeat in this manner until all of the offices have been filled. In case of a tie vote, for any office, each candidate will be given an opportunity to speak to his or her qualifications again. The board will be given new ballots and asked to recast their votes. This process will repeat until a majority vote is reached on one candidate. Any questions? All right, and I will begin. I ask for nominations from the floor for president following the above described procedures. Richard?
I'd like to nominate Ken Knieven for president.
I second.
All those?
No, secret ballot.
All right, anybody else?
You have a chance to state.
Sorry?
Do you have a chance for a statement?
I think I just,
You have to close nominations.
Oh.
yeah, we have to close it. I'll do that. Any others? All right, well,
Move the nominations be closed.
the nominations are now closed. Thank you for the coaching, sir. All right, so thank you for the opportunity. I appreciate the nomination, and as I think I shared with some of you over the last week or so, and many I've discussed this with prior, my interest in continuing as president is really based on, I think, several things that I pointed out. But most importantly, I think we started many things in the last, I'd say year, maybe a year and a half, that I'd like to see us bring to fruition. There are many opportunities here where I think we have some great successes looming in the not-too-distant future with regard to the redevelopment development framework, working with our new CEO, and getting on the ground running. In fact, as I stressed last night, she's running a little too fast and furious in front. The opportunity to continue to focus on those priorities that I think we've laid out in the last 2 years and make sure that we do our best to bring them to fruition. But at the end of the day, I think it's purely continuity. I think this is an opportunity to finish what we started, and I look forward to serving as your president for one more year, and I thank you for the nomination.
Does he know he's running unopposed?
Right.
Yes, I do.
Are we voting now?
Ballots, yes. Thank you, sir. Yep, thank you.
I'm voting twice.
Early in office, my role.
Just like in church. I put my head down and pass.
Oh, goodness me.
I'll pass, because I am not the assistant secretary. I play a different role. It would be inappropriate for me to go. You want me to take your socks off?
Oh,
Microphones are on. It's gonna take him
See what you've
15
done?
minutes.
Yeah, it's gonna be a long year.
You will be on YouTube.
no, I think we already are on YouTube.
We are.
You should give him a table of possible outcomes.
Yeah.
You have a shoehorn I need to put my.
Yeah.
Let it be written, so let it be done. Mr. Knieven is president.
Thank you.
Congratulations.
All right. All right, then we'll continue through the process, and we'll work now with the vice president.
Go ahead.
Ask for nominations for the office of vice president.
I would like to nominate Ellen Graves for vice president, and I'd also like to say that I'm absolutely confident she'll do a terrific job.
And I'd like to second that nomination.
Very good. Are there any other nominations? Any considerations? Okay. The nominations are closed, and we will go through this process again.
Soviet Union.
Yes, it is.
We'll vote.
Soviet Union vote, right? Union vote?
Yeah, you can say she's stuck.
That's a what?
The G1 with me, G1 being Russia.
Okay.
Oh, well. It's always good to have choices.
An aircraft.
I forgot to ask, would you like to say anything?
That's a typo, all right.
Yeah.
Why not? He's out there counting.
Well,
It's the west
I'm
side.
surprised, number one, and I feel very, very humble. Can we have attention down again? Thank you. And
Getting into it.
I feel very grateful to even be nominated for such a prestigious position, and I take it very, very seriously. 6 months ago, I was appointed to the Huntersville Dogwood, never thinking today I'd be sitting at this table and nominated for the position of Vice President. So I want to thank all of you for that. I come to you because I love Reston. I have nothing but admiration for the professionalism of the Reston Association and the staff of Reston Association. I hope to bring a lot of my expertise from my corporate background, my nonprofit background, and as well as my government background. And I want to continue to strengthen this organization. And again, I thank all of you.
Well done. Thank you.
Congratulations, Madam Vice President.
All right. We will now move on to the position of secretary. Do I hear any nominations?
I'd like to nominate Michael Sanyo
I'll
for
second.
secretary.
Okay,
I'd like to second that.
all right. Any other nominations? All right, the nominations are closed. Mike, would you like to take a moment to?
Certainly. I am just very honored and touched to be nominated for this position as secretary that I take very seriously. I moved to Reston 10 years ago, and this has now become my home, and I've just had the honor and privilege to meet many Restonians and become introduced to the RA board some time ago. And I look forward to doing three things in my term as secretary. The first is to advance sustainability, and that is ensuring that Reston continues to be a vibrant, desirable community that attracts progressive developers and others, that preserves and protects the natural areas and the open spaces that we have, and doing it in a way that leads by example, public services and otherwise for the community. So that's the first item. The second is to aggressively pursue amenities, recreational amenities, that support the Reston community, not to duplicate, but to complement what Reston already has. We've got 20,000 additional people likely to come to Reston in the not-too-distant future. We need to plan for that, and we need to be the masters of our own destiny, if you want. And the third item is to support and strengthen the RA board and its governance. And so thank you very, very much for the nomination, and I look forward to serving you as best as I can.
Thank you, Mike.
I just have one request. I'd like to see you see if there's any member comments, just so I can.
I like your sense of humor.
Well,
Thank you.
Right.
That day should.
Only twice.
Sir?
yeah, I mean, it's probably not even.
Okay, the next one will be an actual motion on my part. Yeah. Okay. How do you pronounce your new last name? Tadell?
Yes.
Congratulations, Secretary Sanyo.
Mr. Secretary.
Yes. All right, we'll move on to the position of the Assistant Secretary. I move to appoint Sabrina Faubert Tadelli as Assistant Secretary of the Reston Association. Do I hear a second?
Second.
comments or, given its motion, I'll ask it all in favor of.
What's the new last name?
Tadeli, I
Tadeli,
believe.
Tadele.
Okay.
All those in favor of the motion, please signify by stating aye.
Aye.
Is anybody opposed? Is anybody abstaining? All right, somebody send Sabrina a quick message.
She'll get right to it.
Yeah.
What a wedding present.
The entertainment, I go for entertainment value, folks. All right, if I may, I'll go to the last position, and that is the position of treasurer. Do I hear nominations for the election of treasurer?
I nominate John Higgins.
I'll
second.
Eve will second. All right, do I hear any other nominations for treasurer?
John, this is your chance.
Please? The nominations are closed. John, would you like to take a moment?
Well, I see that I have, according to the agenda, I have 7 minutes. I want to thank you for the nomination. As I've told many of you several times, I very much enjoy serving on this group and being a resource that you, I hope, will use. It's not always been that way, but under Ken's leadership, the board has really come together to think about financial matters, financial management, the future of Reston beyond your term. So I think I may have something to add, and you will determine whether I do or not. I invite you to contact me, call upon me as much as you wish, and I will insert myself from time to time, hopefully discreetly and constructively.
Can we expect more bow ties?
I have 5 minutes left.
Well, then can you demonstrate how to tie a bow tie?
Yes, and then teach us how.
Yes.
Demonstrate.
I'm going to take the tie off right now.
Thank you, John. All right.
That was good.
Pile them up.
This is interesting. The warning says that this may contain almonds. Don't you think they would know?
Yeah, you'd think, I think what they mean is.
They don't know, how am I going to know?
Right.
Congratulations,
Oh,
Treasurer.
thank you.
Somebody said treasurer for life.
Fidel and I have a thing going.
Well, welcome and to the new board and to the new officers. Looking forward to a great new year. So let's get off to a good start. It should be, hopefully we can manage this agenda rather quickly. I know we were talking about that last evening, so let's see what we can do here. So I'm going to move on to the adoption of the meeting agenda. Okay, thank you.
Second.
Great, we're moving fast. Any comments or questions with regard to the agenda? All those in favor of the meeting agenda, please signify by stating aye.
Aye.
Anybody opposed? Is anybody abstaining? All right, I move to approve the board minutes of March 26, 2014, the regular Board of Directors meeting. Do I hear a second?
Second.
Any comments or questions regarding the minutes? Ask the question. All those in favor, please signify by stating aye.
Aye.
Is anybody opposed? Anybody abstaining? All right. We're moving right along, sir.
For the next hour and a half,
Thank you.
I have, it's been a while since we've done this. This is a test. Yay.
Oh, I remember.
Asking each of you to take about, no, I wasn't kidding. Ask you each to fill this out, it's self-scored. We'll go over the answers, because I think sometimes.
I failed this 15 times.
After the election.
Got it.
Oh,
That's one more than my last sobriety test.
All right. Good luck, everybody. No cheating.
I don't think we are the executive organ.
Thank you.
got a question about number 6. There appears to be a verb missing.
Better call Paul. No, I think
Control
it's,
is the verb.
yeah, control. I believe. I don't pretend to be an English teacher, but this was actually reviewed by,
May I read it out loud?
oh, we'll get to it.
Okay.
Okay, all right, that's fair answers.
That's the first one to cheat.
Oh, that's false.
It's a missing comma, I guess.
Comma,
Yes.
got it.
It's my machine.
Can we say 1 minute warning?
Oh, excuse me.
No use of the internet, please.
Oh, my phone is really cute. I like that.
I was just gonna publicly scored.
Yeah, you all will take this to your grave with you,
Oh,
so
geez.
it's all up to you. This is an educational, not a penalized session. All right, number one. Everybody ready?
Ready?
Go.
The association is democracy controlled by its members. True or false?
False.
False. Why is it false? It is false, but why?
We're not a democracy. We're not a,
We're
we're
a
an
corporation.
association. We're not a government,
Representative.
yeah.
You're a corporation. You're based on a corporate model. You're under the laws of the Commonwealth of Virginia. You're a Virginia non-stock corporation. In your book, your hymnals, there are two acts that apply to you. One is the Property Owners Association Act. The other is the Virginia Non-Stock Corporation Act. Both of those laws are directly applicable to Reston Association, which is a Virginia non-stock corporation, membership corporation. As elected members to positions on the board of directors, a board member's duty of loyalty is owed to the members who elected him or her.
False.
Why is that false?
So she told us last time, right?
Well, because our duty is to the RA.
Right.
To the
Turn
corporation.
to page 160 in your hymnals.
Corporation.
160, section 13.1-870.
Hang on.
Sing from this.
170.
We're bringing the piano in now.
Okay, good.
When are we gonna get this in Dropbox?
You can get it online. You can get it on our website.
Here are
Will
my
it say-
counsel
will it
for
say-
thee.
160.
Chadwick?
160, yes it will.
Yeah.
A director shall discharge his or her duty as a director in accordance with his or her good faith business judgment of the best interests of the corporation. So your duties, your standard of conduct is to act in good faith, to make good faith business judgments in the best interest of the corporation. Okay? Any questions about that? Because that's going to be important. Then skip with me, if you will, down a little bit further on that page, actually the next page, a limitation of liability of officers and directors. The statute allows for a limitation of liability with regard to the association and its board members. It limits your liability, but it's limited, if you look on page 162, only the limitation of liability is limited. C says that the liability of an officer or director shall not be limited as provided in this section if the officer or director engaged in a willful misconduct or a knowing violation of criminal law. So not only is there a limitation, but there's a limitation on a limitation. And the limitation also relates to the standard of conduct that you have as board members. Good faith business judgment of the best interests of the corporation. You're here, you come to the meetings, you've reviewed your board packets, you know what the issues are, you discuss them. Lucinda earlier asked about the issue of an open meeting concept. But for all the board members previously, they know that there's an open meeting requirement. The statute requires it. In fact, there's an interesting case that came out of Illinois just recently about open and closed meetings. It was very instructive. But one of the keys is that the members are able to see the board in action. Not that they have the right to participate in the actions that you're taking as a board, but they have the ability to see. Under Virginia law, there's also the ability to make comments during an open forum session held whenever the board wants that forum to be held, but they have the right to make comments about anything that affects them in the context of the association. So realize there is an open meeting requirement. You do have a standard of conduct to live up to as board members, each and every one of you. You're expected to come here to openly discuss issues, and it doesn't mean that you are always going to be in agreement. In fact, it shouldn't be. I've been at too many association meetings where they say, well, we do everything by consensus, and there's never any group of 5, 7, or 9 people that agree on everything. That's important, because the reality is the insights that those other points of view bring to the table are important for everybody to hear and understand, because there's no real clear picture all the time. There's the best decision. It's kind of like taking the bar exam. When you take the bar exam, there are at least 2 right answers on the multi-choice part of the test. You have to pick the best of them. Your job is to pick the best. And as long as you do that, as and act in good faith in the business judgment of the association, on behalf of the association, you'll be protected. Now, just because you are a minority, let's say, of the decision that is made, doesn't mean that you're in the wrong. You have the right to express your point of view, and you have the right to vote accordingly and should vote accordingly. And one of the nice things about Reston is that your minutes are very well taken. You have the vote is based on each member's, how they voted, so that there is a record of that. And that's important too, because corporate memory fails over time. And there are times when members of an association's board, say 2 or 3 years ago, may be involved in a lawsuit 5 years after the fact. And all of a sudden, that corporate memory, if it's not existing in the corporate documents, which are the minutes of the meeting, the members then have faulty memories oftentimes in their favor, having remembered voting the right way at the time, not necessarily the wrong way. So realize that your vote is important, your comments, the judgment that you bring, the experience, your background, your work environment, all the things that you've learned in that work environment, you bring to this table and you share with your fellow members of the board, and you make decisions in the best interest of the association at all times. 3.
Wait, I have just-
Shirley,
sorry. So we're under the federal Open Meetings Act.
no, you're not under the Federal Open Meeting Act. The statute, let's
Which-
take a look at that.
where is the
Look at the
statute?
Virginia Property Owners Association Act. Thank you, Lucinda, for bringing that up. And if you look at page 99, section 55.510.1, that's the open meeting section of the boards of directors. It relates to all meetings of the board. It relates to the annual meeting as well. It says, and this is, all meetings of the board of directors, including any subcommittee or other committee thereof, shall be open to all members of record. The board of directors shall not use work sessions or other informal gatherings of the board of directors to circumvent the open meeting requirements of this section. So what was happening previously were that associations, boards were getting around the rule of an open meeting by holding a meeting the week before, which they would call a work session, but it would be closed. And then the next week, they'd held the board meeting. Well, what was wrong with that? They weren't discussing the issues at the second board meeting. All the discussion took place at the first work session. And as a result, the members weren't seeing what was going on. So the statute was actually changed for that specific reason, to put in the fact that work sessions couldn't be used to get around the meeting, open meeting. You can have work sessions. You can have work sessions, but they've got to be open just like any other meeting, even though no decision is made. Tim?
Well, hypothetically, suppose the group of the board decided to go out and have a beer after a meeting.
I think I'm going to ask that question.
It's later, it's down further.
Yeah, can we
All
wait
right,
till that?
that's
Because
fine.
that is a good point,
Yeah.
and I do want to address that, but I don't want to give away the answer quite yet. Okay, 3, pursuant to a motion from a member at the membership meeting, the membership in attendance votes to approve locating a green cemetery within Reston Association proper. Based on the approved membership vote at the meeting, is the board of directors bound by the membership's decision to locate such a site in Reston? And this is Reston specific.
False.
Why?
Because we still have to act within the best interest of the association, and that may or may not be. I mean, there could be many issues associated with such a decision that are not discussed.
But the membership voted and approved the motion.
Not a democracy.
That's not right. Go back to question
Very
one.
good. But there's another issue as well, and that relates to the fact that under your documents, and this is in section 3.4 of the Reston deed, because of the size of the association, no substantive votes will be conducted at the annual or special meeting of the members. Where a vote of the members is required by the Reston document or required by law to be taken at a meeting, such vote shall be by referendum
Yeah.
in lieu of a meeting. So it's important to remember what your documents say as well. And oftentimes what you want to do in cases where that comes up, like last night, and she wasn't really calling for an actual vote, But I've been at other associations where they don't get in front of that and say, wait a minute, that's really within the board's jurisdiction. That's something that you'd have to amend the documents to change, because the documents give us total authority over administering the operations of the association. And so when that happens at an annual meeting, sometimes the board kind of sit back and don't say anything. And that creates a political issue, because the members go out of there thinking they've approved something and you're gonna do it. And so you need to always, and this goes back to the whole communications issue that you guys have worked hard to develop and to continue to develop, is the idea of making sure your members are aware before they get themselves worked up into a frenzy, and let them make sure that they know where you stand on issues and what the issues are, and that most of the things are gonna fall within your jurisdiction to decide. So it's very important to always get out in front and communicate. That's why I'll put a big plug in for Kirsten and her staff, who do such a fine job on the communication side.
Yes.
Comment.
Oh, I'm sorry, Rich?
Particular case, would it also be an issue that, as suggested last night, if you leased a gravesite for 75 years, would in fact be a lease in exchange for property?
If it were leased, yes, the answer is yes.
Okay, so that would be an additional issue.
There are many issues in that.
Okay.
Yeah, including some health issues too that might come up that the county would have some issues with. 4, as the executive organ of the association, the board sets policy for and makes decisions for and on behalf of the association from one annual meeting until the next.
Tim, and I think this may be a trick question.
There are a couple of issues here. I'm not convinced this board is the executive organ of the association. I think Kate is our executive.
She's your executive, correct.
But
But
we're
you are the executive organ of the association.
And the answer's true.
True. It is true. Because your responsibility is to set the course for the association, to set the policies, to set where you want to go, make the decisions on where the association is headed, as you've done admirably over the past several years. 5, Rest-In Association is solely responsible for the enforcement of the restricted covenants contained in the Rest-In Deed.
Could we go back to 4 for one
Oh, I'm
question?
sorry, sure.
I mean, I hate to bring this up, but is it in fact only for 1 year that our actions are in effect, or?
That's a good question. The answer is it could be. The board makes decisions, though, the board using the annual meeting kind of concept. The board that's elected makes decisions over the course of an annual year, over the course of a year.
Mhm.
And those are the decisions that you make. Anything that a board does can be undone by subsequent boards. So the answer to your question is yes.
I think that can be done in theory.
Right.
I mean,
Because you can't undo a contract that you've entered into
Right.
and already done
Right.
and paid
and you,
for.
yeah, and you also can't do things that are then
But-
not
but-
in the best interest of.
Right.
Yeah.
Right. But it's all still going back to the standard of good faith business judgment of the best interest of the corporation. Right.
Okay, let's be sort of more specific here. And in terms of things like the lighting of the ball fields and the agreement we made with the Newport Shores,
Take off.
is that going to be valid in the future, or does that expire? Is that now, does that need to be passed again as a new motion?
It doesn't, let's take the ball field lights.
Mhm.
That's not going to expire unless the board takes some other action.
Well, the agreement not to light ball fields 2 and 3.
Oh, gotcha. That wouldn't expire either.
I don't recall the exact wording in the resolution, but the reality is that that probably could be changed by subsequent boards if it wasn't somehow otherwise dictated in the actual motion itself. So it depends on what the motion says. Now, even then, I could make an argument that subsequent boards can change the mind because they're in control.
They could say, we're taking the lights out, we're doing, yeah.
Right, right. 5, Rest-In Association is solely responsible for the enforcement of the restricted covenants contained in the Rest-In Deed. Mike said true. Anybody else with Mike?
I think
Wait a minute,
that's
what?
true as well.
Yes, I thought that was true.
When you're going to bed tonight and you have your Rest-In Deeds next to your bed, take a look at section 9, Article 9, section 9.1. The association, any cluster association, any condominium association, or housing cooperative within the property, and any owner shall have the right to enforce all provisions in this deed by any proceeding at law or in equity. So you are not alone. Any individual member of the association, owner, can take action on behalf of enforcing the restrictive covenants. But not on behalf of the resident, it's only on behalf of themselves. They take an action to enforce the covenants.
I don't want to lawyer the word, excuse that expression. But is the RA ultimately responsible? The others may enforce it, but they're not responsible for enforcing. Are we ultimately responsible?
The answer to that question is that it depends.
I kind of knew that would be the
The
answer.
reality is that there are courts of law that say no, an association in its business judgment can make the decision not to enforce a covenant to sue in a particular
I see.
case. So what you get down to is it's a case-by-case basis, because there may be some situations where it wouldn't necessarily make sense from a cost-benefit analysis to do so, dependent upon the circumstances. And there's a case out right out of Fairfax County, Stan Klein, the Honorable Stan Klein, made a ruling to that effect, saying that the association is not obligated to enforce.
I'm thinking of the situation where someone makes lodges a complaint that a property is in violation of the covenants. We look at it, I don't know what we find, but we don't do anything about it. And it's a clear violation. And they insist that we don't act. Might we be liable?
Do we, when you say we don't act, do we do it by simply not acting, or do we make the decision not to enforce?
Two different things.
Let's, either way.
Okay. If we simply let things go and don't make a decision, I think the board's probably more open to liability than if they make a decision affirmatively not to do it.
With some business reason why they're not, I got you.
Correct. I think there's a big difference between the two.
Whoever hired him did a good job.
Yeah.
In the event of any conflict between the Articles of Incorporation, bylaws, or the rest in deed, affectionately termed the governing documents, the Articles of Incorporation filed with the State Corporation Commission control.
I think that's false.
Eve says it's false. Why?
I think the deed,
Deed is-
I think the deed is the dominant document.
That's
I had
correct.
this-
Eve is correct. Not only is she correct, but there's a provision, once again, when you get back into bed tonight and you take the rest in deed, look at Article 9, Section 9.4, conflict. In the event of conflict among the rest in documents, this deed shall control, then the Articles of Incorporation, and then the bylaws. So it is very important to understand that you're very clear as to what the controlling documents are in your case. 7, a meeting of the board is taking place anytime there is a quorum of, a meeting of the board is taking place anytime there is a quorum of board members present, and such meetings have to be open meetings consistent with the Virginia Property Owners Association Act.
I think this is true as
This
well.
kind of goes to Tim's issue raised previously.
It's true.
It's false. It's false.
They have to be conducting some sort of business related to the organization.
And conducting business, actually, the Illinois case I mentioned earlier was one of the things that the court looked at. It's not whether you're making decisions. Conducting business can be discussing the issues. So if you've got 5 board members and you're at a social event and you're discussing the board issues, be careful, or association issues. But if you're at 5 board members at a social event and you're not discussing business and you're not making any decisions, there's no problem with you all being congregated together.
If we ask for member comments at the beginning?
You ask for member,
Right, so we could have a glass of wine.
and then you're gonna ask them over, then you got an open meeting, but then you got another issue.
Oh, we didn't announce.
Because you didn't give notice of your meeting. And all meetings, open meetings of the board have to be announced, and notice has to be given.
Happy hour.
Corporate documents.
You are thinking out, I like it, I like
So
it.
just be aware, it is false. Emailing my fellow board members is not a meeting and is not prohibited by law.
If that's not true, we're all in trouble.
I was gonna say, you're right.
It is true,
I was gonna
at
say.
this point. There was an interesting case about 10 years ago, came out of the city of Fredericksburg. The city council had a 9-member city council, and 5 members were of the same mind and would always get together on the internet. And they kept trading back emails back and forth. And finally, one of the citizens of Fredericksburg challenged them and took them all the way up to the Virginia Supreme Court. The Virginia Supreme Court, once again, found itself in a position where it made new verbiage. They came up with the word simultaneity. What they said was that when looking at the facts and the information going back and forth, it was by standard email. And there could be 5 minutes between a transmission and another, it could be 2 hours, it could be a day. Court said, under those circumstances, that's not a meeting.
Right.
And what they said was, it really matters on the simultaneity. So if you were in a chat room, you were all in a chat room together, you were someplace where you all had instant, maybe Skype, where you all had instantaneous interaction with one another, that would be potentially a meeting. The closer you get to being able to discuss instantaneously with one another, that's what's going to trigger it. But under the current circumstances, simply emailing each other, doing anything on the internet is not prohibited by law, whether it's the group or individuals emailing one another as well. So be aware of that.
Can I go back to number 6 briefly?
Oh, sure, Rich, I'm sorry.
You brought up you brought up in regard to Eve's comment that if no an announcement had to be made in regards to the meeting, what is the time limitations or period of time required for the announcement of meetings?
Generally, it's as soon as the board knows. So as soon as the board knows that through a packet that the information has gone out, there is the requirement that members be notified as well. And in fact, members can request specific notice to themselves, which we then would have to comply with either by mail or electronically. Let me see.
Is there a minimum time?
No, I was going to say, I in fact have that list. You don't see it when I send out an email, but I have a distribution list of about 100 people right now that I send the packet out to. I have not time limited it unless somebody, for my personal sake, I mean, I'll keep them on until they tell me to take it off. But I think the last time I checked, there's a 1-year minimum that you have to keep them on unless they request to be put back.
That's not the
The
question.
question is in 55.510B. Notice of the time, date, and place of each meeting of the Board of Directors or any subcommittee or other committee, so realize it's not just the board.
Right.
Shall be published where it is reasonably calculated to be available to a majority of the lot owners. Now,
It doesn't say the time.
right. Now, what they do say is that the lot owner shall be, and this goes into the individual lot owners. Lot owner may make a request to be notified on a continual basis of any such meetings, which request shall be made at least once a year in writing and include lot owner's name, so on and so forth. Notice reasonable under this is the next paragraph. Notice reasonable under the circumstances of special or emergency meetings shall be given contemporaneously with notice provided members of the association's board of directors or any subcommittee or other committee thereof conducting the meeting. So what you really get down to is when the board is aware of a meeting, the membership needs to be aware of a meeting. So most of the time, you have an annual list that goes out to all the board members. And as soon as that list goes out, it's up on the website.
You mean the list of meetings?
Right.
Right.
Which is the list that gives notice to all members of when the board meetings are. If there's a change in that, if there is a special meeting of the board, then as soon as the board is aware of when that meeting is going to be, you have to give notice reasonable under the circumstances to reach a majority of your members. So as soon as you guys know, they're supposed to know. And that's the way the statute works it.
Thank you.
You're welcome. Let's see. A board member's fiduciary duty to the association means that it should limit its expenditures of association funds in order to minimize the assessments and any increases thereto owed by its members. False.
False.
And why is that false?
the ability to borrow.
Well, we have to,
Best
Not-
interest-
Because
yeah,
it's the best interest
Best
of the
interest of the
corporation.
Right.
Right.
It's the same basis. Your
Otherwise-
standard is, what does the corporation need to function? What is its requirements in terms of the assessments that you need to charge in order to provide the services that your members are getting or that they're expecting in terms of the organization? So, good faith business judgment of the best interests of the corporation. 10, the Board of Directors pursuant to the Virginia Property Owners Association Act and the association's governing documents can delegate authority and responsibility for certain of its duties and responsibilities.
True.
I think that's true.
I'm surprised, Dave, that you didn't realize this was a trick question.
They're all trick questions.
I'd say yes to duties, but no to
Oh,
responsibilities.
right.
Correct.
Oh, yeah.
You can delegate authority,
Yeah, you can't delegate
but
duties.
ultimate responsibility comes back to the board. When you delegate authority, that's an action of the board.
Right.
And you have to make sure that the people that you're delegating that authority to are following through and doing what they're expected to do, whether it's officers, staff, agents,
Right.
contractors, whomever. And so your responsibility is to always delegate, you can delegate authority, but you can't delegate that ultimate responsibility. It falls back to you.
So I was hoping to
Now,
follow.
I cannot take credit for these next two questions. These were added by Mr. Larry Butler, who is as tricky and
Yes.
as I am. The 11, the annual assessment for 2015 was set in the 2014-2015 biennial budget development process last year. False.
I think we had a number for it, but we didn't set it.
Right,
We could
exactly.
change that this
Right.
year.
Right.
It is false.
Yeah.
Would you agree, Mr. Butler? Okay, good. 12, a board advisory committee passes a motion to request the board to do X, Y, and Z. The board must take action on this motion.
False.
False.
Mr. Butler agrees with you.
As we know.
It's false. Finally, extra credit. What goes on in executive session stays in executive session.
Only if it's in Las Vegas.
Yeah, Las Vegas.
Trick question.
Right. True, it's supposed to.
Almost true.
Almost true. That's- Now,
Except
this
for when
is,
it doesn't.
this is an accounting term, almost.
Yeah. What was discussed
Explain your,
has to be made public, not,
the subject matter.
right, the subject matter, not the details of it.
It is important, and it is statutorily recognized. You'll turn with me to page, let's see, it's page 99 once again, the bottom of it, paragraph C. The Board of Directors or any subcommittee or other committee thereof may convene an executive session to consider personnel matters, consult with legal counsel, review and consider contracts pending or probable litigation, and matters involving violations of the Declaration of Rules and Regulations. So realize, the statute has said we require open meetings of our associations in the Commonwealth of Virginia. But there are times that we also realize that it is important to go into executive session to discuss issues as outlined in paragraph C. And it's very important to realize that that is a right that you have, and a responsibility goes with that. Because as board members, when you're in executive session, anything that's discussed is considered confidential in that meeting. The subject matter, as John pointed out, is not, because you have to kind of recognize what that subject matter is. Alternatively, anything that's discussed in that executive session should remain in that executive session. And if something happens, and this is the downside of executive session, or saying something outside of executive session, if something happens to the association detrimentally as a result of discussions that were held in executive session that then came out of executive session and were discussed openly by third parties, with third parties, if that damages the association in any way, ultimately that will come back to haunt you individually as board members. Individually, if you were the one who shared that information. Because the association has the ability to go after board members for damages sustained by it, which the board member created. So when we're talking about this, and let me give you a practical example. We represented a large condominium association. Actually, we were called in as insurance defense on behalf of the association and its insurance carrier. And we were at a meeting. It was, had been an open meeting. We went into executive session for the sole purpose of discussing the litigation at hand. There were 2 members on the board. It was a 5-member board. 2 members on the board who were in cahoots with the plaintiff. They were friends of, they were friends, neighbors, social events, whether they had notice of their meetings or not. And they ended up in a situation where they took information from that executive session where we were discussing litigation strategy and took it out of the executive session, went home and talked to their friend about it. Next morning, I got a call from the attorney on the other side of the case saying, what you're suggesting isn't going to work. Your strategy, and this is why, and I'm going to go down why your strategy isn't going to be successful. So immediately, what's my obligation? Got to notify the board, but I also got to notify the insurance carrier. Insurance carrier, one of the provisions in your contract of insurance with any insurance carrier is that you will, the association and the board, cooperate with the defense or prosecution of the case that they're covering. Were those 2 board members cooperating in the prosecution or defense of that case? No, they weren't. So let's assume, for the purposes of the discussion, that that's happened. The insurance company says, what next? We're not covering you any longer. And as a result, we're removing coverage and you're on your own. So now who picks up the cost of that litigation?
Association.
The association does. But what does the association have against those 2 board members? A cause of action. Because they damaged the association. They had insurance coverage, they lost insurance coverage, and they were now going to be out the money for the litigation. So sometimes we don't always think about what the long-term effect of our actions are, but especially for the new board members, you all have been elected now. You're on the board, welcome. You do have responsibilities. There is a sense of responsibility that should come with this position, as the rest of this board has. And so when making your decisions, make sure that you're discussing it in full, you're getting all of your issues raised. When you're asked if you have a comment on an issue, put it out there, because anything you bring to the table is going to be important for everybody else at the table. Whether they agree with you or not is not the issue. The fact of it is there may be different facets of the problem that they're not aware of that you could bring to the table and that they now have a better understanding of. And that's what when we talk about what the board's responsibility is, ultimately it's to make a fully informed decision. So if you don't have information that you still think you need in order to make a decision, table the decision. But make the best decision you can with the information you have, in good faith and the best interest of the association, and you'll be protected. And always act in the interest of the association, not in anybody else's interest, and you'll be fine. You do have protection. You've got D&O coverage. You've got indemnification under the documents and under state law. So there are protections that are afforded to you as long as, once again, you're acting within the scope of your responsibilities and under the standard that you have under the code. As long as that's happening, there's not a problem. That doesn't mean you're not going to be sued. You can be sued anytime and for anything. But you'll be protected as long as you're acting within the scope of your authority, which is one of the reasons you have staff and Kate and me here to work with you so that you know what rights you do have, and also as long as you're acting in the standard that the corporate code sets. And the reality is you're the only ones ultimately that know whether you're in that standard or not and whether you're acting in accordance with that standard. Here endeth the lesson for the day. Thank you all for your time.
Are we waiting on
attention.
Curve
Thank you.
Thank you very much, Ken.
Please
Well
note the
done.
time.
Well done.
Yeah.
Ron, for a final question,
Ooh, sure.
in regards to.
Did you say final question? Be
Can we
careful
do
what you
motion?
say. Final question.
Not the final. Tabling the motion, can a motion be tabled in perpetuity, or does it periodically have to be tabled again?
A motion can be tabled until it's taken off the table. And the problem is that if it's an issue that's confronting the association and it's not dealt with by the association, it becomes a problem. Because when you made the motion, when the motion was first made and it was seconded and you discussed it, let's assume that you did all those. There was an issue confronting the association that action needed to be taken. One of the major things that I think a board is responsible for doing is taking action. And that taking action, it means making a decision. Putting it on the table, either for a meeting or ad infinitum, is problematic because you're not making a decision. I would rather have a board of directors make a negative decision that they're not going to do anything on that issue than not to just simply table it, because you're not acting in the best interest of the association by not acting on it.
I bring that up because then question 12, in spirit, the answer would be true. Eventually, you have to take an action.
Except there, as Larry explained to me, that his point was the advisory committee portion of that. Now, the reality is that I too think that an action does need to be taken at some point. Although some things you don't require action, you simply accept the report, for instance. So the reality is it depends on what we're talking about. But I think if there's an action to be taken that the board feels is there and a motion has been made and seconded, that really necessitates the board taking action on that ultimately. I don't think tabling it is going to sit well with either the members or with law.
Thank you.
Thank you. Mr. President, it's your meeting.
Thank you, sir.
This is a time where we will now put our secretary to the test. This is a time for member and board comments. Mr. Secretary, do you know if we have any comments?
I guess I have to go and do that.
Would you please, sir?
Ike, it's in the walk. It's in the walk.
Yes,
That's
make
it.
I don't see it. None? All right. All right, just to double, well, let me just check for sure. Anybody in the room that did not sign up that would like to take a moment to offer the board any of your comments? All right. Okay, then I will toss this to the board, especially I look forward to hearing from our new directors. An opportunity for you to give us your comments. Why don't you start with you, Ellen?
Well, I'm delighted to be here, and I certainly would like to congratulate our newest members of our board and welcome them.
Thank you.
I just want to repeat that comment. Congratulations, and really look forward to working with you over the next year.
Yeah, I don't have anything. Welcome.
Welcome.
Yeah,
three.
I mean, obviously, welcome, guys. I think it's going to be really interesting and lots of good work in front of us to get done.
Yeah, I second the things that have already been said, so welcome.
So I'm the first one to say something new.
Right.
It's just thank you. Pleasure to be here. I did circulate an item at an appropriate time. Mr. President, we can address this. Copies were made for me, but I provided some information on a perspective on sustainability, and at an appropriate time, this slide is available for us to discuss. Would you like me to circulate them now or at some other time?
I did do that for
They've
you
already-
today. I sent it around to
Okay.
everybody
We all have
electronically.
them.
Okay,
Thank you.
you're welcome.
I'm pleased to be here to be a part of the RA board. I'm looking forward to working with everyone to help look out for the best interests of the corporation.
Good job, Jeff. Well said. Well
Talk
said.
to the lawyers.
Made Ken happy, this Ken.
I'm excited to be here. It's a terrific opportunity for me, and I'm just ready to jump in and work for the community.
Excellent.
I welcome everybody as well and look forward to a productive year.
It is and continues to be an honor and privilege to be here. Welcome to 3 new board members. I would encourage you to continue asking the questions, as well as the existing board members, that all the questions were good tonight, and I appreciate the input, because that makes us all better in the end. Thank you.
Welcome, new board directors. It's great to have you here, and congratulations to our new officers. I look forward to working with everybody over the coming year.
Thank you, everybody. I'll just reiterate, congratulations to our new directors. I think we're going to have a very good year. And for those that are new to the process, don't hesitate to share a quick comment or question. We're happy to make sure that it's important that you're clear on something that's going on in the process. So if it's new to you, and I remember my first few days, I do remember that feeling, don't hesitate. Just let us know. Ken is here, Kate is here, we're all here to make sure that if you're feeling like something needs to be looked at or addressed, we can handle that as best as possible, keeping within the process. All right. With that, and again, let's get on with it. Next item is item F, the receipt of our audited financial statements. Andy, are you, Andy?
Heavy.
If you don't need a printed copy, I know you sent around electronic copies.
I did.
It wouldn't hurt.
You're free to keep them or give them. Thank you. I'm gonna have to,
Good time.
you guys share.
I'm okay, I've got one, so I will.
I have one.
We're about 35 minutes ahead. We'll be out of here by 8:15.
All right. Good evening to all. My name is Andy Afwang from BDO USA. I'm an audit senior manager in charge of the audit engagement for this year. Lori DeArmond is the engagement partner. Unfortunately, she has a prior commitment, so I'll be presenting to you the audited financial statements for December 31st, 2013. First of all, I would like to congratulate the new board members and the new officers for this year. If you have any questions with regards to the financial statements, please feel free to chime in, raise your hand, or ask me the question. We have completed our audit of the consolidated financial statements of Reston Association and Friends of Reston as of and for the year ended December 31st, 2013. And the good news is that we have issued an unmodified opinion, which is a clean opinion, and we did not have any issues with regards to the audit. Our audit was conducted in accordance with the generally accepted auditing standards. Our objective of our audit was to obtain reasonable but not absolute assurance about whether the financial statements are free from from material misstatements. These financial statements that David distributed to you were presented and reviewed and recommended for the board approval by the fiscal committee. We had our meeting March 31st, 2013, and they did not have any changes to what was presented as a draft to them. The management provided us with full cooperation during the audit, and all the records and information requested by us were provided to us, and I think the audit went very smoothly this year. I want to reiterate to you all that the financial statements are the responsibility of management with regards to the preparation and fair presentation in accordance with generally accepted audit accounting standards. Our responsibility is to express an opinion on those financial statements, and our opinion is clean. And I just wanted to let you all know that we did not have any corrected misstatements or any adjustments with the numbers or disclosures in the financial statements. As part of our audit, we also considered the internal controls over the financial reporting on those financial statements. If we have noted of any deficiencies or findings or material weaknesses or significant deficiencies in the internal control over financial reporting, we are required to report those to you. And I'm happy to announce that there are no deficiencies in internal control over financial reporting. To give you a little bit of details on the financial statements, the association had a very good year in 2013. The results of operations, or what we call the statement of revenues and expenses, the association made about $466,000 of excess of revenues over expenses. The current assets, the current balance sheet shows about $29.8 million of assets, and most of these assets are from the property and equipment of the association. Most of the notes to the financial statements are very consistent with the previous year's financial statements. There's no significant changes to them other than the 2013 balances. The last two schedules in those financial statements, I just wanted to clarify that those supplementary schedules are not audited. One of them is the supplementary information on future major repairs and replacement, which is required to be included in the financial statements by the Financial Accounting Standards Board and the Property Owners Association Act. This is just a summary of the study that was conducted in 2009, and the next study has to be done on or before end of this year. So we're expecting to have a new study for the next year's financial statement. And the last thing that I wanted to mention to you all is that BDO is independent of the association. We did not have any conflict of interest with the association, and I would like to commend the financial team of Reston, headed by Dave, for being very helpful to us and made our audit very smoothly. That's all I have for now. And if you have any questions, sure.
A couple questions, and get used to questions. You use the term material deficiencies as your responsibility as an auditor. Could you give me a definition of that so I'm sure I understand it? Maybe our counsel can do the same.
All right, sure. Material deficiencies are pertaining to internal controls, wherein if we note of any breakdown in internal control, especially on the financial reporting side, we're required to present it to you all. A deficiency in internal control exists when design or operation of control does not allow management or employees in the course of performing their assigned function to prevent or detect and correct misstatements in a timely manner. So if we note of any instances like that, we are required to present those to you. And there's nothing that we have noted this year during the course of the audit.
Thank you, that's helpful. A quick follow-up question, just for mechanics. This is in fact an annual report, and it's reported on a yearly basis. When's closeout for the organization? When do actually the numbers have to get in?
Not sure. What do you mean by closeout?
For example, in all the organizations I've worked in, we've had a time in which we've had to have all of our expenditures accounted for, and then we close out our spending for that year. So does that match the actual fiscal year in this case, or is there a different
Calendar
concept?
year, so,
So you're pretty close to actually operating on an annual basis?
Correct.
Okay, thank you.
And in addition to that, we also perform search for unrecorded liabilities. So the date of the opinion is March 31st. So if there's any expenses that came in after December 31st, 2013, which pertains to 2013, we will highlight it to the finance team to accrue those expenses.
Thank you.
Yeah, and we did not note of any because they already did their accrual.
Anybody else?
Yes.
Yeah, I was just wondering, do you have any suggestions, having reviewed our books, about the way we present our financial situation? Is there anything you think could be done to make it clearer or more in conformance with other reports of similar organizations?
I mean, I think the association way of reporting it to the board, I mean, I think the finance team reported to you in a monthly basis or something. That is very consistent to other associations. In most cases, the acceptable way of reporting is on a quarterly basis, but you're doing it more frequently. The presentation, the way they present the financial statements to the board is very acceptable too, and it's very consistent with the way we have issued the financial statements. So, I mean, I think you're getting all of the information that you need to decide to make your decisions, and all of the information are available. All of the information available, to you all as well.
I do believe that David will probably be bringing a different format to you at some point in time, still probably on a monthly basis, but the way it looks, my guess, will change. That's one of the first things he noticed when he came on board is the manner in which the information was presented. Not the kind of information, but the way it was presented will change.
That's precisely what I was getting at.
Right, and we're gonna go through, so as the fiscal committee, some of one of the discussion points for the upcoming meetings is getting ideas on how to streamline what is presented and, still have budget versus actual, but maybe present some more management type reports.
I think there's more a question for David, but your input might be important.
Sure.
I don't ever remember seeing an annual statement of the Friends of Reston. This is a consolidated statement, and the two are kind of mixed, and you can't really look at this and match this to our own financial statement. I don't ever recall seeing an annual statement for Friends.
There is, on page 22, there's a summary of the results of Friends of Reston.
Summary, but I guess I want to dig a little further into the weeds.
Sure. If that's something you'd like to see, I can certainly
That be
distribute
made
that
available
internally.
to us?
Sure.
Should it be?
That's up to you. I mean, if you want to see it, I can give it to you, absolutely.
And it's also not a required disclosure in the financial statements because we're presenting it on a consolidated basis, but it's up to the management if you all want to disclose it.
Do you actually review the Friends of Reston as well, or just the RA books?
We do include the Friends of Reston.
Another question, if I may. I had a friend review this who was not acquainted with accounting language, and there was one term in there, bad debt expense for $125,000 on page 11. What does that mean?
Would you like to answer that? Okay. All right. So if Reston does not foresee to collect assessment dues or whatever receivables that you may have in your balance sheet, if any other ways of trying to collect those balances, and if the management feels that there's no chance of collecting those fees,
I see.
they write it off as an expense.
Yeah, and it's essentially any assessments that are greater than 1 year past due, we make a provision or an allowance for bad debts. We ultimately end up collecting in most cases.
Okay.
But, you know, it's a conservative policy that we make an allowance for anything that's over a year old.
So it's an annual statement of what you intend to pursue in the coming years in regards to debts to the association.
Yeah, and our collections team, so Chadwick handles anything that's, we push to them items for collection past a certain due date.
Yeah. Bad debt is bad debt for the accounting purposes. It's not necessarily bad debt for the association.
Right.
Because we're still going after some of those things.
That's why I had someone else take a look at it and see a
Right.
term they thought would they might not understand.
So
We
is
don't
that,
give up easily.
Yep. And the good thing about it is the association put a lien on the property as well.
Yeah.
So they get sold, you'll end up collecting whatever is,
But even then, there are times when the association does make the decision not to collect or is incapable of collecting, especially if the property has been foreclosed upon and the debtor is basically penniless. So at some point, you might have to make a decision not to collect on the total amount. But most of the time, as has been presented, there's a lien against the property. We go after the individual personally through a private action, civil action, and so that you're protected to the extent that we can do that and collect as well.
so this number here is just an estimate then, of it's kind of a set aside to say we think it's going to be about $125,000 as opposed to we have a list of these people and it adds up to $125,000?
Correct. And that's the expense side of it. So we do have the allowance side. It is an estimate.
Okay.
Yep.
Thank you, folks. Appreciate it very
Thanks so
much.
much.
all right. Thank you all.
Yes. All right.
Move to accept the report.
We hear a second? Any comments or questions to the motion? All those in favor of the motion, please signify by stating aye.
Aye.
Is anybody opposed?
You completely missed the motion.
Excuse us, guys. Guys,
Yeah, we're in the
we're in the middle of a motion. All those in favor of the motion as identified again?
Motion is to accept the report of the, of BDO. It's the audited financial statements.
I believe Eve seconded. I'm not, sorry. Ellen,
Seconded.
too many E's there.
So I'll ask the question again. All those in favor of the motion, please signify by stating aye.
Aye.
Is anybody opposed? Anybody abstaining? Thank you, folks. All right. We're on to item G, board committee assignments. Kate?
Very much, Lisa, I appreciate that. At this time of year, one of the things that we do is talk about board committee assignments and the importance of selecting which one that you would like to sit on. So I wanted to do a brief overview of what it means to be assigned to a committee. First, the association has board committees, advisory committees, we've got the design review board, we've got the covenants committee, and we have maybe community councils or other community committees that we're a part of, that we sit on. The board committees include the legal committee, the board planning committee, and the fiscal committee. Of those three committees, the fiscal committee is the only one that is not solely populated by the board of directors. That is comprised of 7 individuals who have a financial background in the community, as well as the treasurer of the association. The advisory committees are primarily composed of residents in the community, property owners, renters in the community who have a particular interest for one of the committee subject areas. There are occasions where some of those committees might have some special requirements. For example, the 55-plus advisory committee also can have representation from the various fellowship houses. Now, that might mean somebody who works in their management office, who runs their events and programs. They do not live in the association. They are not members of the association. However, they represent our members and can help us in programming for that age range. Same thing with the communications, I apologize, same thing with the Reston Neighborhood Advisory Committee. We have clusters that are run by management companies, condominiums run by management companies, or apartment complexes. We might want the people who run those different groups to be a part of that committee. Those are the exceptions with our advisory committees. The Design Review Board is appointed by the Reston Association Board, again, comprised of members who own property in Reston. There are architectural members there, there are lay members as well. Covenants Committee, also comprised of Reston Association members, and there's representation in all 4 of the different districts there. Community councils, that there are a variety of them in the community. At the moment, we only have one to which we have an appointment, and that is IPAR. We used to have, there used to be a task force, the Hunter Mill District Task Force for the Master Plan. That's disbanded at this point, and when the next committee comes up, I'm sure we'll have some appointments on there as well. So those are the different types of groups that you have the opportunity to participate on for the Board of Directors. It comes up at this time every year, and what we're interested in is getting your preferences. Again, there are 2 different ways that you would serve on a committee. One is as an actual voting member of the committee. The other is just a liaison, and I want to talk about the differences between the 2. So this is all in your Dropbox as well, and I'll make sure that I send an electronic copy to those who don't have Dropbox yet. So once you're appointed, if you're appointed to serve on the Legal Committee, the Fiscal Committee, or the Board Planning Committee, or any other special committee of the board, you are a full voting member of that body. Your presence is counted toward quorum. It's important that you're there. You also are held to the same attendance criteria as any other of the committee members. Attendance criteria is this. It's important that you show up to the meetings. If you can't show up to the meeting, you have to let the meeting coordinator know. Whoever is the chair, whoever's the staff liaison, just so they know for quorum purposes. If you're not there for 3 consecutive meetings, we're going to ask, are you okay? Do you have time for this? If not, we'll try and find somebody else to take your spot on that. If you're appointed to serve as a liaison is someone who is appointed to the Design Review Board, the Covenants Committee, or one of the advisory committees. That role is different. It's not a voting member of that body. You're not participating in the conversation as a voting member at that time. Your sole role is to be a line of communication between that body and this body, the Board of Directors. So what you do not have a vote on a matter, as I said. You go, you're not counted toward quorum, and you are held to the same attendance criteria. You're not held to the same attendance criteria. In fact, as a liaison, you only have to show up quarterly. That doesn't mean that they don't want to see you more often, especially with the committees. They like that connection. Typically with a committee, what you're doing is you're bringing information back to the Board of Directors about what's going on. More specifically, with the Design Review Board and the Covenants Committee, there are some specific things that we're hoping are going to happen. And by the way, all of the information that I'm providing is written out in resolution format. I did attach it to a packet that's before you so that you all have it. So these are this is information that is available. There are no changes to what we've provided. The Design Review Board and Covenants Committee, you want to attend at least one meeting of the DRB or Covenants Committee. At least one. You'd like to go quarterly. If you want to go to all of them, you can. In coordination with the DRB and Covenants Committee chairs, you are going to be presenting quarterly reports to the RA Board of Directors on activities of those bodies. To my knowledge, that hasn't been done yet. So that's something for anybody who's interested in that particular role at serving a liaison to either of those bodies. That would be great. It's a great way to connect those bodies back to this Board of Directors. You're also going to be assisting in the development of methods to obtain member feedback with those 2 groups. What are the interactions like? What do you as a board need to be paying attention to? What adjustments need to be made to the design guidelines, or possibly even to the covenants, policies, and rules that we have in place? Next would be to co-host with the chairs of both of those bodies, DRB and Covenants Committee, an annual joint meeting of this body, the Design Review Board, and the Covenants Committee. These are some of the very most important committees that we have in the organization because it goes right to the purposes of the organization to protect the value of property. Design value as well as maintenance and upkeep. Maintenance and upkeep is what the Covenants Committee is responsible for. New design is what the Design Review Board is responsible for. Next would be to facilitate a board-required public hearing on any design guideline and use maintenance standard changes, new policies that are being put in place. And next is to help educate members on the role of the Design Review Board and Covenants Committee in those meetings. These roles are very important, either as a voting member in the committees that you're looking at or as a liaison, and making sure that the connection, primary connection as a liaison between the advisory committees, the DRB, and the covenants back to this body is maintained. That's the intent of those. So, in the packets before you, and I will, before the end of the weekend, I'll send an electronic version to you, because I want to find out what your preferences are. Actually, Ken wants to know what your preferences are. I'm just going to be serving as a conduit, a collector of information, put that together for him in a matrix so that he can work to determine who best to place. Take a look at the descriptions. We have 7 different committees. We have, in terms of advisory committees, we have the 3 board committees, we have the Design Review Board, the Covenants Committee, and we have IPAR as well. So take a look, read through those, and what you want to do is determine what your preferences are. Try and pick your top 3 in the different groupings. Which one do you want to serve on? What's most important to you? Prioritize using 1, 2, and 3. You can use an X. Just give us an indication of which ones you're most interested in. You can get that back to me by the 21st. That would be great because we need to make these assignments before May. There are committees that meet in May, and I know that our staff as well as the leadership of those committees are interested in knowing who they'll be working with soon. So I just wanted to make sure you had all of that in
So
front of you.
included in that information, you'll have the scheduling of the committee meetings.
Of the time,
All of
dates and
that,
times
yeah,
when they come back.
exactly.
I did not provide that, but I'll make sure that Sabrina does
That's
so that
important.
you can get an idea
Right.
of when they meet, because that might
Absolutely.
that might mean something to you as to which one you're interested in.
Right.
And she will be back next week, so I will assign her that task to make sure she gets that to you as well. Thank you for that point.
How many committees do we liaison with, like, are we assigned to?
It depends on you, to be quite honest with you. In the past, I have had board directors who've had up to 6 different connections. They just raised their hand and said, I'd be happy to, I'd be happy to, I'd be happy to. It depends on what you got time, how much time you have and what you want to give. You really put into this as much as you can.
So do we indicate on the paper how many committees we want to be on?
You can, you know, if you indicate a willingness, it might take you up on it.
No, absolutely, absolutely. You know, obviously, we're trying to take into consideration, you know, we all have other lives, but we also recognize that we have commitments to the committees as well. So, you know, be honest with yourself, and we'll do the best we can. You know, we're not dictating what's going to happen here, per se.
But we can still go to the committee meetings even if we're not assigned.
Absolutely. You can-
Absolutely, you're more than welcome. Everything's open, just as Ken indicated. I apologize, Ken. I
No,
didn't
that's
jump
okay.
in there.
I'm done.
I apologize.
Well,
But-
we can't be voting members. of that.
Correct.
That's correct.
Correct. So an advisory committee, even as the liaison, you're not voting on that. You're just providing information back. You're not counted toward quorum. Attending, again, listening, you know, maybe providing feedback during member comments, but not, you know, you don't want to, but you don't want to get in the way of the work that they're doing.
Mhm.
That's the intent there. So you want to let your committees, who you've appointed, do that work. And come back to you, to the full body, with information back to them. Any other questions?
That helps.
Okay.
Rachel?
Yes, ma'am.
The board planning committee is the decision maker on the makeup of the advisory committees. They approve new members to the advisory committees, correct?
They're going to be, they're going to be doing the answer is no is correct, is no. But they're going to be conducting interviews and providing feedback back to you as to who they recommend for appointment. So everyone everyone who was interviewed, all of the information will be provided to the Board of Directors with a recommendation from the Board Planning Committee. So that you still get to see and have a conversation about who's best to appoint, so.
So I made that point so that if you're a liaison to a particular committee, the board planning committee, while they do the interviews and do a review process, that's still shared with the entire board. So you as the liaison, you may not be a member of the board planning committee. Nonetheless, you have full opportunity to comment.
Absolutely.
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 Good point.
Anything else?
Thank you, Kate.
Great, yeah, no problem. Just wanted to make sure you all have that. If you can get that back by the 21st, that would be great.
Kate, I think you're still up.
Yes, I'm going to sit down for
Okay.
the next one now. Okay.
All right.
We have on your calendars, I believe I sent out to all of you a reminder about the upcoming board development training that we're having with BoardSource. And what I did is I put in your packets, that's on May the 3rd, 9 o'clock, Comstock Partners, right close to Metro Station, across from Reston Mini Storage. The address I do believe I sent to all of you. We're very fortunate to have Comstock hosting us. They're providing breakfast and lunch for us that day. But the first step in the process is information gathering and analysis. And I'm very happy to report to you that a survey was sent out about 7-8 days ago for the current board of directors, the board that came before this one. So just the group that turned over last night to complete a survey. And it took quite a bit of time to fill that out. I had to fill that out as well as the sitting board directors. And there was 100% participation. And I can't tell you how much I appreciate that. I know Alice has worked very hard. She's been working with BoardSource to put this together for us. And that's going to make a big difference in the outcome of the meeting that we have on the 3rd. So with that information in hand, with the document review and interpretive analysis report that's being put together by our consultant at BoardSource, we should have a pretty good program on May the 3rd. It is a half-day session. The end result of that I highlighted in red for you in your packets, and that will be a board development action plan that you will help craft and put in place. And it's just going to set the tone for how you do business together and on behalf of the association. And we've got a really fantastic firm that's schooled in this, that does it all the time. I thought it was very important that we have the best of the best to come and work with us on that. But I really think it's going to be a good program. Again, thank you, Alice, for helping me to put it together. And I look forward to your participation on it that day.
Thank you. That should be a good day. Looking forward to it. All right. If there are no other items, I think we've concluded our first meeting ahead of schedule.
Since Joe's not here, I move to adjourn.
I second that.
In case everybody's waiting.
Yes. Any comments or discussions with regard to adjourning? All those in favor of the motion, please signify by saying aye.
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 Is anybody opposed? Is anybody abstaining? We are adjourned. Thank you, folks. Well done.
Yeah.
What works best for you?
Good. I actually have another meeting to go to down the hall.
Do we ask them about
With
the,
the pedestrian bike, but it's probably over.
Yeah, oh, absolutely. Yeah.
7.
Thank you. I can,
They've run it.
confident about some areas, but for example, the.
yeah, would you welcome
I
that?
would look forward, yes, I would. I would welcome very much.
Yeah.
Say Friday's looking good.
I've got a good background. Yeah, I've got a brother who's.
It'll be great working with you.
Oh, mine, the honor is mine. Are you kidding? If that's, you want to get together, like, late enough where we can
Turning
do
over a
it?
new leaf.
Yeah, they're
Turning over a new leaf.
Have over at the plaza?
How much is the 160?
Or is there a better haunt for you?
gather my stuff.
That's what I'm thinking. Yeah.